2010-101760. Count 1, kidnapping, dangerous crime against children and a domestic violence offense. Count 2, conspiracy to commit custodial interference, a domestic violence offense. Count 3, custodial interference, a domestic violence offense. The grand jurors of Maricopa County accuse Elizabeth Johnson on this 14th day of January 2010, charging that in Maricopa County, Arizona, count 1, Elizabeth Johnson on or between the 18th day of December 2009 and the 30th day of December 2009, knowingly restrained Gabriel S. Johnson, under 15 years of age, with the intent to place Logan McQuarrie in reasonable apprehension of imminent physical injury to Gabriel Johnson in violation of Arizona law. Count 2, Elizabeth Johnson on or between the 18th day of December 2009 and the 26th day of December 2009 did conspire to commit the offense of custodial interference. In conspiring to commit such offense, Elizabeth Johnson and other conspirators, both known and unknown, with the intent to promote or aid the commission of an offense, did agree with one or more persons that at least one of them or another person would engage in conduct constituting the offense of custodial interference. In furtherance of this conspiracy and to effect the objects therefore, defendant and other co-conspirators, both known and unknown, would commit overt acts in violation of Arizona law. Count 3, Elizabeth Johnson on or between the 18th day of December 2009 and the 26th day of December 2009 removed Gabriel S. Johnson from Arizona, knowing or having reason to know that she had no legal right to do so, took, enticed, or kept from lawful custody Gabriel S. Johnson, a child who was entrusted by authority of the law to the custody of Logan McQuarrie in violation of Arizona law. A true bill dated January 14, 2010. Andrew Thomas, Maricopa County Attorney, signed by Bell Whitney, Deputy County Attorney, and signed by the foreperson of the grand jury, to which the defendant has pled not guilty as to each count alleged. Okay, so that is the actual indictment. Now the next thing we're going to do is we're going to read the jury instructions, and as I said, you have copies of the preliminary jury instructions. Let me ask counsel, since I'm reading verbatim the jury instructions and we have a copy of them, are we okay with not requiring the court reporter to take down my reading of the jury instructions? Is the state okay?
No objection.
Is the defense okay with that?
No objection, Judge.
Okay, all right. State of Arizona versus Elizabeth Johnson, preliminary instructions of law. Ladies and gentlemen, now that you've been sworn, I will briefly tell you something about your duties as jurors and give you some instructions. At the end of the trial, I will give you more detailed instructions, and those instructions will control your deliberations. It will be your duty to decide the facts. You must decide the facts only from the evidence produced in court. You must not speculate or guess about any fact. You must not be influenced by sympathy or prejudice. You will hear the evidence, decide the facts, and then apply the law I will give you to those facts. That is how you will reach your verdict. In doing so, you must follow that law whether you agree with it or not. You must not take anything I may say or do during the trial as indicating any opinion about the facts. You, and you alone, are the judges of the facts. Importance of jury service. Jury service is an important part of our system of justice with a long and distinguished tradition in American law. From the beginning, American law has viewed the jury system as an effective means of drawing on the collective wisdom, experience, and fact-finding abilities of persons such as yourselves. While it may be an occasional inconvenience or worse, jury service is an important responsibility for you, one which I am sure you will take seriously. Evidence. You will decide what the facts are from the evidence presented here in court. That evidence will consist of testimony of witnesses, any documents and other things received into evidence as exhibits, and any evidence stipulated to by the parties or that you are instructed to consider. You may hear reference to exhibits that are not admitted and are not asked to be admitted. These exhibits are not admitted as evidence, but the information from them that is testified to by witnesses is evidence that you may consider. You will decide the credibility of the witnesses and weight to be given to any evidence presented in the case, whether it is direct evidence or circumstantial evidence. Direct and circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is a physical exhibit or the testimony of a witness who saw, heard, touched, smelled, or otherwise actually perceived an event. Circumstantial evidence is the proof of a fact or facts from which the existence of another fact may be determined. The law makes no distinction between direct and circumstantial evidence. You must determine the weight to be given to all the evidence without regard to whether it is direct or circumstantial. Stipulations. During the trial, the lawyers are permitted to stipulate that certain evidence exists. This means both sides agree that evidence exists and is to be considered by you during your deliberations at the conclusion of the trial. Evidence, statements of lawyers, and rulings. As I mentioned earlier, it is your job to decide from the evidence what the facts are. Here are 6 rules on what is and what is not evidence. Number 1, evidence to be considered. You must determine the facts only from the testimony of witnesses and from exhibits admitted in evidence. Anything you may see or hear when the court is not in session, even if what you see or hear is done or said by one of the parties or by one of the witnesses, is not evidence and must not be considered by you. If you should hear or see anything pertaining to the case outside the courtroom, or if anyone should attempt to speak to you about this case outside the courtroom, please report to me as soon as you can. Number 2, lawyer statements. Statements or arguments made by the lawyers in the case are not evidence. Their purpose is to help you understand the evidence and law. Number 3, questions to a witness. A question is not evidence. A question can only be used to give meaning to a witness's answer. Number 4, objections to questions. If a lawyer objects to a question and I do not allow the witness to answer, you must not try to guess what the answer might have been. You must also not try to guess the reason why the lawyer objected in the first place. Number 5, rejected evidence. At times during the trial, evidence may be offered that I do not admit as evidence. When evidence is not admitted, you must not consider it for any purpose. Number 6, stricken evidence. At times, I may order some evidence to be stricken from the record. Then it is no longer evidence, and you must not consider it for any purpose. Rulings of the court. Admission of evidence in court is governed by rules of law. I will apply those rules and resolve any issues that arise during the trial concerning the admission of evidence. If an objection to a question is sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit is offered into evidence and an objection to it is sustained, you must not consider that exhibit as evidence. If testimony is ordered stricken from the record, you must not consider that testimony for any purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from me of the credibility of the witnesses or weight you should give to any evidence that has been admitted. Exclusion of witnesses. The rule of exclusion of witnesses is in effect and will be observed by all witnesses until the trial is over and the result is announced. This means that all witnesses will remain outside the courtroom during the entire trial except when one is called to the witness stand. They will wait in the area directed by the bailiff unless other arrangements have been made with the attorney who has called them. The rule also forbids witnesses from telling anyone but the lawyers what they will testify about or what they have testified to. If witnesses do talk to the lawyers about their testimony, other witnesses and jurors should avoid being present or overhearing. The lawyers are directed to inform all their witnesses of these rules and to remind them of their obligations from time to time as may be necessary. The parties and their lawyers should keep a careful lookout to prevent any potential witness from remaining in the courtroom if they accidentally enter. This rule does not apply to the defendant. Court rules also permit a representative of law enforcement who may be a witness to stay in the courtroom during trial to assist the state. Bench conferences and recesses. From time to time during the trial, it may become necessary for me to talk with the attorneys out of the hearing of the jury, either by having a conference at the bench when the jury is present in the courtroom or by calling a recess. Please understand that while you are waiting, we are working. The purpose of these conferences is not to keep relevant information from you, but to decide how certain evidence is to be treated under the rules of evidence and to avoid confusion and error. We will, of course, do what we can to keep the number and length of these conferences to a minimum. I may not always grant an attorney's request for a conference. Do not consider my granting or denying a request for a conference as any indication of my opinion of the case or of what your verdict should be. Please do not be concerned with what we are discussing at any bench conference we may have. Please respect the privacy of those participating in the bench conference in order to maintain the fairness of the trial. Credibility of witnesses. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the tests for accuracy and truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness has testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness has any motive, bias, or prejudice, whether the witness is contradicted by anything the witness said or wrote before trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in light of reason, common sense, and experience. No transcript available to jury taking notes. At the end of the trial, you will have to make your decision based on what you recall of the evidence. You will not be given a written transcript of any testimony. You should pay close attention to the testimony as it is given. You have been provided with notepads and pens. The court encourages you to take notes during the trial if you wish to do so. Do not let note-taking distract you so that you miss hearing or seeing other testimony. You may use your notes during your deliberations at the end of the trial. Until then, keep your notes to yourself. During recesses in the trial, you may leave your notes on your seat. Your notes are confidential. My bailiff will guard them. No one will be allowed to read your notes. Whether you take notes or not, you should rely upon your own memory of what was said and not be overly influenced by the notes of other jurors. After you've rendered your verdict, the bailiff will collect your notes and destroy them. Do not be influenced at all by my taking notes at times. What I write down may have nothing to do with what you will be concerned with at this trial. Admonition. I'm now going to say a few words about your conduct as jurors. I'm going to give you some do's and don'ts, mostly don'ts, which I will call the admonition. Do wear your juror badge at all times in and around the courthouse so everyone will know you are on a jury. Each of you has gained knowledge and information from the experiences you have had prior to this trial. Once this trial has begun, you are to determine the facts of this case only from the evidence that is presented in this courtroom. Arizona law prohibits a juror from receiving evidence not properly admitted at trial. Therefore, do not do any research or make any investigation about the case on your own. Do not view or visit the locations where the events of the case took place. Do not consult any source such as a newspaper, a dictionary, a reference manual, television, radio, or the internet for information. If you have a question or need additional information, submit your request in writing and I will discuss it with the attorneys. Do not talk to anyone about the case or about anyone who has anything to do with it, and do not let anyone talk to you about those matters until the trial has ended and you have been discharged as jurors. This prohibition about not discussing the case includes using email, Facebook, MySpace, Twitter, instant messaging, BlackBerry messaging, iPhones, iTouches, Google, Yahoo, or any internet search engine, or any other form of electronic communication for any purpose whatsoever if it relates in any way to this case. This includes, but is not limited to, blogging about the case or your experience as a juror on this case, discussing the evidence, the lawyers, the parties, the court, your deliberations, your reactions to testimony or exhibits, or any aspect of the case, or your courtroom experience with anyone whatsoever until the trial is ended and you've been discharged as jurors. Until then, you may tell people you are on a jury, and you may tell them the estimated schedule for the trial, but do not tell them anything else except to say you cannot talk about the trial until it is over. One reason for these prohibitions is because the trial process works by each side knowing exactly what evidence is being considered by you and what law you are applying to the facts that you find. As I previously told you, the only evidence you are to consider in this matter is that which is introduced in the courtroom. The law that you are to apply is the law that I give you in the final instructions. This prohibits you from consulting any outside source. If you have cell phones, laptops, or other communication devices, please turn them off and do not turn them on while in the courtroom. You may use them only during breaks, so long as you do not use them to communicate about any matter having to do with the case. You are not permitted to take notes with laptops, Blackberries, tape recorders, or any other electronic device. You are only permitted to take notes on the notepad provided by the court. Devices that can take pictures are prohibited and may not be used for any purpose. It is your duty not to speak with or permit yourselves to be addressed by any person on any subject connected with the trial. If someone should try to talk to you about the case, stop him or her or walk away. If you should overhear others talking about the case, stop them or walk away. If anything like this does happen, report it to me or any member of my staff at the phone number provided as soon as you can. To avoid even the appearance of improper conduct, do not talk to any of the parties, the lawyers, the witnesses, or media representatives about anything until the case is over, even if your conversation with them has nothing to do with the case. For example, you might pass an attorney in the hall and ask what good restaurants there are downtown, and someone from a distance may think you are talking about the case. So again, please avoid even the appearance of improper conduct. The lawyers and parties have been given the same instruction about not speaking with you jurors, so do not think they are being unfriendly to you. When you go home tonight and family and friends ask what the case is about, remember you cannot speak with them about the case. All you can tell them is that you're on a jury, the estimated schedule for the trial, and that you cannot talk about the case until it is over. In a civil case, the jurors are permitted to discuss the evidence during the trial while the trial progresses. In a criminal case such as this, however, the jurors are not permitted to discuss the evidence until all the evidence has been presented and the jurors have retired to deliberate on the verdict. Therefore, during breaks and recesses, whether you are assembled in the jury room or not, you shall not discuss any aspect of the case with each other until the case is submitted to you for your deliberations at the end of the trial. Again, if you have any question or need additional information, submit your request in writing and I will discuss it with the attorneys. During the trial, you are not to engage in any conduct that impairs or interferes with your ability to see, to hear, and understand the court proceedings. Do not form final opinions about any fact or about the outcome of the case until you have heard and considered all of the evidence, the closing arguments, and the rest of the instructions I will give you on the law. Keep an open mind during the trial. Form your final opinions only after you have had an opportunity to discuss the case with each other in the jury room at the end of the trial. Please advise me in writing immediately if you believe that any juror has violated any provision of this admonition. Before each recess, I will not repeat the entire admonition I have just given you, thankfully. I will probably refer to it by saying, please remember the admonition, or something like that. However, even if I forget to make any reference to it, remember that the admonition still applies at all times during the trial. Media coverage. There will be news media coverage of this trial. You must be careful to avoid any such coverage at all times until the trial is over and you've been discharged as jurors. Until then, do not watch local news programs on television. Do not watch any national networks that cover trials or offer commentary on trials. Do not read any newspaper coverage of the trial. Do not view any internet site, whether it be a news or social media site, that may have coverage of this trial or the people involved in it. If you do encounter something about this case in the news or social media during the trial, end your exposure to it and report it to me as soon as you can. Do not be concerned about cameras in the courtroom. Court rules require that the proceedings be photographed or televised in such a way that no juror can be recognized. Questions by jurors. If at any time during the trial you have difficulty hearing or seeing something that you should be hearing or seeing, or if you get into personal distress for any reason, raise your hand and let me know. If you have any questions about parking, restaurants, or other matters relating to jury service, feel free to ask one of the court staff. But remember that the admonition applies to court staff as it does to everyone else, so do not try to discuss the case with court staff. If you have a question about the case for a witness or for me, write it down, but do not sign it. Hand the question to the bailiff. If your question is for a witness who is about to leave the witness stand, please signal the bailiff or me before the witness leaves the stand. The lawyers and I will discuss the question. The rules of evidence or other rules of law may prevent some questions from being asked. If the rules permit the question and the answer is available, an answer will be given at the earliest opportunity. When we do not ask a question, it is no reflection on the person submitting it. You should attach no significance to the failure to ask a question. I will apply the same legal standards to your questions as I do to the questions asked by the lawyers. If a particular question is not asked, please do not guess why or what the answer might have been. Alternate jurors. The law provides for a jury of 12 persons in a case such as this. We have more than 12 jurors so that if a juror becomes ill or has a personal emergency, the trial can continue without that juror. At the end of the case, alternate jurors will be determined by lot in a drawing to be held in open court. Please do not be concerned with who may or may not be chosen as an alternate at the end of the case. Constitutional right not to testify. A defendant in a criminal case has a constitutional right to not testify at trial, and the exercise of that right cannot be considered by the jury in determining whether a defendant is guilty or not guilty. Presumption of innocence and burden of proof. The state has charged the defendant with 3 crimes. The charges are not evidence against the defendant. You must not think the defendant is guilty just because the defendant has been charged with a crime. The defendant has pled not guilty. The defendant's plea of not guilty means that the state must prove every part of each charge beyond a reasonable doubt. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crimes charged, you must find her guilty. If, on the other hand, you think there is a real possibility that she is not guilty, you must give her the benefit of the doubt and find her not guilty. In deciding whether the defendant is guilty or not guilty, do not consider the possible punishment. The charged offenses. To assist you in considering the evidence that will be presented during the trial, I will now tell you about the crimes with which the defendant is charged. The defendant is charged with kidnapping. The crime of kidnapping requires proof that the defendant knowingly restrained Gabriel Johnson with the intent to place Logan McQuarrie in reasonable apprehension of imminent physical injury to Gabriel Johnson, custodial interference, and conspiracy to commit custodial interference. The crime of custodial interference requires proof that the defendant, number 1, took, enticed, or kept from lawful custody any child entrusted by authority of law to the custody of another person or institution, and 2, knew or had reason to know that the defendant had no legal right to do so. The element of conspiracy requires proof that, number 1, the defendant agreed with one or more persons that one of them or another person would engage in certain conduct, and, number 2, the defendant intended to promote or assist in the commission of such conduct, and, number 3, the intended conduct would constitute a crime, and, number 4, an overt act was committed in furtherance of such conduct. The defendant has pled not guilty to these charges. The state must prove each element of the charged crimes beyond a reasonable doubt. I will give you more details and definitions about the alleged crimes in the final jury instructions. Scheduling during trial. The trial is expected to last through Tuesday, November 6th. We will all do our best to move the case along, but delays sometimes occur. These won't be anyone's fault, so don't hold them against the parties. Delays usually occur because the attorneys and I often need to resolve certain legal matters before these matters may be presented to you in court, or because I am busy with matters in other cases. The usual hours of trial will be from 10:30 a.m. to 5 p.m. We will recess at noon and begin again at 1:30. Unless a different starting time is announced prior to recessing for the evening, you may assume a starting time of 10:30 a.m. for the next day. At the beginning of the day, please assemble in the jury room for this division. Please do not come back into the courtroom until you are called by the bailiff. Order of trial. Criminal trials generally proceed in the following order. First, the prosecuting attorney will make an opening statement giving a preview of the case. The defendant's attorney may make an opening statement outlining the defense case immediately after the prosecutor's statement, or it may be postponed until after the state's case has been presented. What is said in opening statements is not evidence, nor is it an argument. The purpose of an opening statement is to help you prepare for anticipated evidence. Second, the state will present its evidence. After the state finishes the presentation of its evidence, the defendant may present evidence. If the defendant does produce evidence, the state may present additional or rebuttal evidence. With each witness, there is a direct examination, a cross-examination by the opposing side, and finally, redirect examination. This usually ends the testimony of that witness. Third, after all the evidence is in, I will read and give you copies of the final instructions, the rules of law you must follow in reaching your verdict. Fourth, the attorneys will make closing arguments to tell you what they think the evidence shows and how they think you should decide the case. The state has the right to open and close the argument, since the state has the burden of proof. Just as in opening statements, what is said in closing arguments is not evidence. Fifth, you will deliberate in the jury room about the evidence and rules of law in an effort to reach the verdict. If you unanimously agree upon the verdict, it will be read in court with you and the parties present. Finally, you will be discharged and released from the admonition. Okay, back on the record. Couple follow-up things. Number one, jury questions. In Arizona, jurors are permitted to ask questions. And believe it or not, in most states, jurors are not permitted to ask questions. We were one of the first states that permitted jurors to ask questions. More states are doing it now, but I think it's still a minority of states. Here's how it's going to work for us. If you believe you've got a question for a witness, wait until after that witness has finished testifying. After that witness is finished, I will always look over to the jury and say, does anyone have any questions for the witness? Write down that question or those questions. Kim will come over and get the questions. I'll review them with the lawyers to make sure that we can ask them, and then if appropriate, we'll ask the question. So that's how we'll do it. You can't just raise your hand and ask a question. Just write it down, and you can write it down while the witness is testifying if you would like going forward. Okay, so we're ready for opening statements, and as I told you a moment ago, the state gets to go first since the state has the burden of proof. So Ms. Ramuno, you may proceed with the state's opening statement.
Thank you, Your Honor. Good morning, ladies and gentlemen. In a matter of 3 weeks' time, the lives of Logan McQuarrie and Gabriel Johnson were forever altered by the fury of a woman scorned and by the obsession and meddling of a woman by the name of Tammy Smith. This case is about the quest to remove Logan McQuarrie from the life of his child, Gabriel Johnson, at the hands of two women. One woman intent on adopting a child or getting a child without regard to the rights of the father, and one woman intent on retaliation. A combination that resulted in the complete disregard for the right of a father to raise his child, the complete disregard for the right of a child to be raised by his father, and a complete disregard for the legal system. A combination that resulted in disaster. This is Elizabeth Johnson and Logan McQuarrie. They knew each other from grade school at a young age and became a couple in the year 2007. In the year 2008, they learned that they were pregnant and were going to be having a child. Like any other relationship, the relationship had its ups and downs, especially, they tried to make it work, especially after the birth of their son, Gabriel Johnson, on May 3rd, 2009. However, there came a point in the relationship when it became clear that the relationship was on a decline and the fate of this young family was uncertain. The first sign of big trouble came in June of 2009. Logan and Elizabeth had gotten into an argument, and in response to that argument, the defendant, Elizabeth Johnson, left the state of Arizona with her child Gabriel without Logan's knowledge. After a couple days, he realized that she was in Boston visiting her grandmother. During that trip, they reconciled over the phone. She flew back to the state of Arizona. And it was a fateful day in June of 2009 that she met a woman by the name of Tammy Smith on a layover in Indianapolis, both on their way back to the state of Arizona. They met, they talked, the topic of adoption came up. Tammy Smith was interested in adding another child to her family. She was not able to have any more children. And Elizabeth had a child that she told Tammy Smith she was willing to consider giving up for adoption. Tammy Smith gave her phone number at that time in the hopes that Elizabeth would call her and that she could adopt Gabriel Johnson. However, Elizabeth returned to the state of Arizona, and her and Logan resumed their life as normal. And during the months of June through December 2009, they lived together, and as of December 2009, they lived together in a home in Tempe, Arizona. However, on the date of December 8th, 2009, Logan and the defendant got into another argument, and Logan had had enough. He ended their relationship that day, and in response, the defendant told him, "Leave the house and take the baby with you." So he did. Immediately that day, he went to his grandmother's home and visited with her. A few hours later, however, he's contacted by the Tempe Police Department because the defendant had called them and reported that her child had been missing and that Logan had taken him without her permission. As soon as he hears this, he takes the baby immediately back, leaves Gabriel Johnson with Elizabeth Johnson at the home in Tempe. On this very same day, Elizabeth Johnson contacts Tammy Smith about adopting Gabriel Johnson. On this very day, December 8th, 2009, this is the last time Logan McQuarrie ever saw his son. Because as of December 9th, 2009, Elizabeth notified him that she intended on giving up the baby for adoption. In fact, he was made aware when she called him and said that he needed to sign the adoption papers. He told her he was not interested, that he did not want to give Gabriel up for adoption, that he wanted to take care of him himself. However, the defendant had already taken action on her plan. That very same day, as of 1 p.m., she had given Gabriel Johnson to the Smith family, Tammy and Jack Smith. She had also signed over a guardianship document giving them legal authority over that child, totally unbeknownst to Logan McQuarrie. He goes to work that day. She starts calling. Different clerks and employees are answering the phone. He doesn't go to the phone because they're in an argument. He doesn't want to create a disturbance at work. 6:41 p.m., she shows up. And she wants to deal with the issue of the adoption right then and there. She demands that he signs paperwork. She demands that they talk about the issue while he's at work at the 99-cent store. However, she creates such a disturbance at that 99-cent store that one of the managers calls the Tempe Police Department. The Tempe Police Department comes over. When they come over at about 6:45 p.m., Elizabeth Johnson again claims that Gabriel Johnson is missing, that Logan has kidnapped him, taken him, and is responsible for the unknown whereabouts of Gabriel Johnson. All while knowing the whole time that Gabriel Johnson is just fine at the Smith residence. Over the course of the next several hours, Logan and his family members that are located here in Arizona are questioned by the police. The police go to their homes to check if the baby is there. They go to the home in Tempe where they had previously lived together. The baby's not there. After several hours of questioning and investigation, Elizabeth finally says, "Oh, okay, he is at the Smith residence." Tempe Police Department goes out to the Smith residence. They find that Gabriel is there. He is fine. He is safe. and they are provided with the guardianship document that she had signed earlier that day. In the meantime, Logan is left without knowing where his son is. Because he has not established legal paternity over the child, because they were not married and he did not establish paternity, the police are prevented from giving him much information on where the child is, because the legal custodian at that time is Elizabeth Johnson. So despite the fact that he's cared for this child for most of his life, that he's the only father this child has ever known, he does not know where his child is. He does not know the Smith family. He has no clue who these people are. After discussing what his next steps should be with his family and his father in particular, Logan McQuarrie decides to take proper legal action, and he goes to the Maricopa County Superior Court and he files for legal custody of his child. A hearing date is set for later in the month, and on that same day, the defendant is visited by Alicia Shumway of Children's Protective Services of the state of Arizona. When asked to see Gabriel, Elizabeth tells Miss Shumway, "Well, he's not here. I gave him up for adoption. He's with this family, the Smith family." Miss Shumway is concerned at that point, obviously, because she needs to check on the welfare of this child. She sets up an appointment for a couple days later to come back and see Gabriel and make sure that he's safe. On December 11, 2009, Elizabeth Johnson also posts to an unknown user on MySpace that she has given up the child for adoption. During this time, over the next couple days, Elizabeth begins to move on with her life. She posts an ad on Craigslist looking for a roommate. She finds a roommate, a man by the name of Malcolm Phipps, who comes and moves into the home on or about December 12, 2009. As of December 13, 2009, Logan McQuarrie is still letting the defendant know that he wants to take care of Gabriel. He posts on her MySpace, "I want to take care of Gabriel. Let's not do this. Give him to me. Don't give him up." On December 14th of 2009, Ms. Shumway from CPS appears at the Tempe home where Elizabeth is with Gabriel Johnson, and this time Tammy Smith is there with her. Ms. Shumway explains to her that this adoption is not possible because legal proceedings have been begun in Maricopa County Superior Court, and until that's resolved or until Logan McQuarrie signs away his rights, they can't do anything. She sternly tells them that, and at this time Elizabeth Johnson changes her story and says, "Oh no, I never intended, I'm not giving him up for adoption." At that point, Ms. Shumway leaves, and Gabriel is allowed to go back home with Miss Smith, contrary to the instructions of Miss Shumway from CPS. He doesn't stay at the home with Elizabeth. He goes back home to the Smiths. December 15th, 2009, Logan McQuarrie continues to plead with Elizabeth. He posts another message on her MySpace wall about him wanting to be able to take care of the child, to let him try and do it, to let him do it. On December 16, 2009, the day before the court hearing, Elizabeth and Logan meet up, and they discuss a custody arrangement between the two of them that they agree upon, and they reconcile, but only for the night. When they show up in court next day, Judge McVeigh declares that Logan is the father of the child, and that he orders joint custody between the two parties. He also orders that Logan is entitled to his first visitation on the dates of December 20th to 23rd, 2009. On this date, Gabriel's still in the custody of the Smiths, but on the 20th, Logan McQuarrie is supposed to get him. However, on Friday, December 18th, 2009, 2 days before Logan McQuarrie is scheduled to have his son, Elizabeth Johnson clears her bank accounts and leaves the state of Arizona with Gabriel Johnson, and no one knows where she is. By Sunday, December 20th, Logan figures out that something's gone awry. He goes over to the house Knocks on the door, no one answers. Elizabeth's not there, the baby's not there. She doesn't have a cell phone at the time. He doesn't have a way of getting in contact with her. He spends the next few days repeatedly going back to the trailer, trying to figure out where she is, and in a state of disarray because he has no idea where she is and where his son is. On December 21st, then, he goes back to court and he lets the judge know what has happened. The judge orders temporary full custody to be given to Logan McQuarrie. He also orders a hearing to be held on December 28, 2009, at which time Elizabeth Johnson is expected to appear with the child. On this same date, he calls the Tempe Police Department to assist him in trying to locate the whereabouts of Elizabeth Johnson and or his son. Between the dates of December 21st and 22nd, 2009, Logan McQuarrie finds a number for Tammy Smith. It's a business number, and he calls her. And after a few conversations, it becomes apparent that Tammy Smith has been in contact with Elizabeth Johnson, and that Elizabeth Johnson is in the state of Texas. While they give Logan McQuarrie Elizabeth Johnson's phone number, her and her husband, Jack, talk to her and tell him not to call her, to let them handle the situation. They also talk to him about possibly adopting Gabriel and discuss the benefits of doing so. Despite these people being strangers, despite him not knowing anything about them, he decides to listen to their advice at that time, and he doesn't call Elizabeth for the next few days. However, he is very uncomfortable after speaking with the Smiths and the things that they have to say to him. December 22nd, 2009, Logan hears from Elizabeth Johnson via MySpace. She posts a message to him, clearly indicating that she's upset about the demise of their relationship. However, he only hears from her via MySpace that day. The same day, Tammy Smith text messages Logan McQuarrie and suggests that they get together, her and her husband and him and his dad, to talk about Elizabeth Johnson. She also suggests or tells him that she doesn't trust you or your dad. The only way she'll come back is if my attorney faxes the signed papers to her so she won't get in trouble and Gabriel be with us. Essentially leveraging the adoption of Gabriel Johnson against the idea of never seeing Elizabeth or Gabriel Johnson again. He tells Tammy Smith and her husband he's not interested in adoption and to stop calling him and not bring it up again. By December 26, 2009, Logan McQuarrie can't take it anymore, and he decides to call Elizabeth Johnson. At about 12 p.m. that day, they talk for about 4 or 5 minutes. The very next day, December 27, 2009, Logan McQuarrie hears from Elizabeth Johnson in a text that changes his world forever. She texts him, "I killed him." He immediately calls her, speaks to her for about 1 minute and 37 seconds, and again calls her back and speaks to her for about 9 minutes and 11 seconds. And during these conversations, Logan McQuarrie hears from Elizabeth Johnson that she has killed their son, that she has suffocated him, that she has stuffed him in a bag, put him in a dumpster, described horrific acts to Logan McQuarrie, and then blames it on him and tells him that it's his fault she did it and that he made her do it. Obviously, Logan goes to the police. He shows them his phone. He shows them the text message. He gives them a recorder that contains the recording of these phone calls. Because a few weeks earlier, his father, Frank McQuarrie, had told him, "You should probably start taping your interactions with these people," because he was afraid of what might happen. Everything was up in the air. There were different things being said back and forth. So he provides that to the police. While he's at the police station, his phone is dying, however, so he had to shut it off. And at about 12:40 that afternoon, he turns his phone back on again to show the police the text message, and he receives additional text messages that were made earlier by Elizabeth Johnson. She calls him a coward bitch. She says, pathetic loser, run to daddy. She says, you will never find me. I'm already boarding a plane out of the country. When I'm safe, I'll email you the exact location of dead Gabriel's little blue body. If the garbage does not come first, well, I'm done with you two fucks. This is what liars like you deserve. Based on the dire nature of these text messages and the conversations that the police heard, the Tempe Police Department immediately takes action. They send officers out to the home in Tempe. After a while, the roommate, he's never seen the baby live at that address. When he first moved in, there were baby items there, or when he first looked at the house, there were baby items there, but by the time he moved in the next day, there were no baby items there whatsoever. They contact the Smiths. The Smiths don't have the baby. They finally get a hold of the defendant on her cell phone. She says, yeah, I'm in the state of Texas. I'm on my way back to Arizona. The baby's in the car. We're fine. No baby's heard in the background. They ask her to pull over on the interstate so that a San Antonio officer can come check on their welfare, and she refuses to do so. Based on this information, based on the text, the phone calls, her refusal to pull over and let Texas authorities know that the baby's okay, a nationwide search is begun at this time. Quickly, the San Antonio Police Department become involved, the FBI becomes involved, all on the lookout for Elizabeth Johnson and her son Gabriel. Over the next day, the whole day of December 27th, 2009, the Tempe Police Department are able to track the defendant's movement via her cell phone, a cell phone that she had obtained with a San Antonio phone number. However, her movement clearly indicates she's not heading back towards Arizona, she's heading towards Houston, the complete opposite direction. All contact with her is lost at the end of the day on December 27th, 2009, and it's not until December 30th, 2009, several days later, that they are able to track her and find her in Miami Beach, Florida. On December 29th, 2009, what happens is she uses her MySpace account. She actually uses it to write to Tammy Smith. Search warrants are issued, and they track the computer that she used down to a hostel in the Miami Beach area. When they arrive in the Miami Beach area, the Miami Beach police are given flyers of what she looks like, and they immediately begin a search of the area, particularly going directly to the hostel where this message came from. She's eventually found under an assumed name of Victoria Evans, and Gabriel is nowhere to be found. Surveillance tapes are reviewed, witnesses are spoken to. The last time anyone has seen Gabriel Johnson was in the state of Texas on or about December 26th or 27th, 2009. On December 27th, 2009, in particular, she goes to a bus station in San Antonio, Texas. Witnesses there observe that she has no baby, she just has a backpack. She gets on that bus, which takes her to Miami Beach, Florida. You will hear that she was then questioned by Miami Beach police detective, and she was also questioned by a special agent from the FBI on between the dates of December 30th and 31st, 2009. And what she tells them at that time is that, oh, Gabriel's fine. She gave him to a couple, an unknown couple, a strange couple, was not able to provide any description that led to an identification of a couple, any description that would be able to lead to the whereabouts of Gabriel Johnson. And for her actions over the course of the dates of December 18th through December 30th, 2009, the defendant is charged with 3 counts. She is charged with kidnapping, custodial interference, and conspiracy to commit custodial interference. The evidence in this case, during this trial, you will hear from a number of witnesses. You're going to hear from Logan McQuarrie. You're going to hear in his own words about the events that took place during this time period. He's going to tell you how everything went down. You're going to hear from his father. You're going to hear from people who know Tammy Smith. You're going to hear from a number of police officers who were involved in this investigation. And I'm not going to give you all their names because there's just far too many at this point. You're going to hear from the FBI agent who spoke to her. You're going to hear from the Miami Beach detective who spoke to her. You're going to see the court documents and records that granted a legal custody to Logan McQuarrie. You're going to see the text messages, the pictures on the phone, the text records, the phone records. You're going to hear the conversations that occurred between Tammy Smith, Logan McQuarrie, and the defendant in this case. What you will not hear, however, is evidence of where Gabriel Johnson is now. And the judge has already instructed you that that is not an issue for you to consider in this case, and that you are not to speculate on that. We don't have any information to give you about where he is. However, it is your job in this case to decide the facts and apply it to the law with regard to the charges that the defendant is charged with. And what that evidence will show is that for the co-defendant Tammy Smith in this case, Gabriel Johnson was an object to be desired. He was something she wanted to add to her family. And because of that, she agreed upon a plan with Elizabeth Johnson, and she took action in that plan in order to keep Gabriel Johnson away from Logan McQuarrie. And what you will hear, the evidence in this case will show, with regard to the defendant, Elizabeth Johnson, is that Gabriel Johnson was a pawn. He was a tool. He was a piece in a game. And the object of that game to her was to keep Gabriel Johnson from Logan McQuarrie, was to retaliate against Logan McQuarrie for breaking up with her. And her intent was also to place him in fear for the safety of his son. And in each of those women's different motivations or desires in obtaining Gabriel Johnson, crimes were committed. Crimes that have irreparable consequences. And at the end of this case, after you hear all the evidence and you consider all the evidence, you will have more than enough evidence to find the defendant guilty as charged. Thank you.
Thank you, Mr. Romano. Mr. Victor?
Thank you, Judge. Well, good morning, ladies and gentlemen. You made it on the jury, and congratulations for that. I know it's been a very long process, lots of delays, lots of sort of probing questions. Some of them may be embarrassing or uncomfortable, but I want to thank you for serving. And let me start with a piece of good news. My opening statement is going to be very brief, much briefer than the state's. Now, I know that already that you are not surprised to learn that there's going to be evidence in this case that may cause you to not like Elizabeth Johnson. I know you're not surprised about that. I also know that you're not surprised to learn that there may be evidence in this case that would suggest that baby Gabriel is still missing. I know you remember that I sort of tipped you off to this, maybe not so subtly, on Tuesday of this week when I addressed the entire panel. I sort of made it clear that there was going to be evidence in this case about that. And I know you recall that I asked questions about whether or not you would be able, notwithstanding these issues, to focus on the elements of the crimes charged. What I'm going to ask you to do is listen to all the evidence, but to keep that in mind, to keep in mind as you hear the evidence that really it's about focusing on the elements of the crimes charged. Now, you may be surprised to know that there's really not very much of a dispute over the facts of what happened here. In fact, the defense agrees with much, if not all, of the facts that will be presented in this case. The defense isn't going to dispute at any time that there was a bad relationship between Elizabeth Johnson and Logan McQuarrie. We're not going to dispute that there were fights about lots of things, fights about Gabriel especially. We're not going to dispute that Elizabeth Johnson wanted to give Gabriel up for adoption and that Logan McQuarrie didn't want to do that. We won't dispute that Tammy Smith wanted to adopt Gabriel. No dispute in this case about that. No dispute that Tammy Smith sort of undertook some actions, even to forge some documents. She was desperate to get Gabriel Johnson into her hands. There's not going to be any dispute about that from the defense in this case. Indeed, there is very little to no dispute about the timeline of events in this case. We agree that somewhere around December 18 of 2009, possibly December 19 of 2009, Elizabeth Johnson left the state of Arizona. She took Gabriel. She went to Texas. However, you're not going to hear any evidence that there was anything wrong with that. Indeed, Elizabeth Johnson was entitled to take Gabriel Johnson wherever she wanted at that point in time. She wasn't violating any order whatsoever on that day. That notwithstanding, on December 20th, 2009, as you've heard, there was an order, and you're going to hear evidence about that order that Judge McVeigh issued from the Maricopa County Superior Court that says on December 20th, 2009, that Elizabeth Johnson was obligated to return Gabriel Johnson to Logan McQuarrie, to give him to Logan McQuarrie. The evidence is going to be that Elizabeth Johnson didn't do that. Elizabeth Johnson was in Texas on that day. She failed to give Gabriel to Logan on that day. There's not going to be a dispute on that point. 12/26/2009 is the last day that we have any evidence whatsoever of Elizabeth Johnson being with Gabriel Johnson. You're going to hear evidence that this was at the Homegate Hotel in Texas, in San Antonio. Now, Elizabeth Johnson gave conflicting accounts of what happened with Gabriel in Texas, to Gabriel in Texas. That's not going to be resolved in this case. Indeed, that's not even an issue in this case. You've heard the judge already say, you've heard me already say, the judge will say it again, I'll say it again. Gabriel's current status, Gabriel's whereabouts is simply not an issue in this case. That's the 800-pound gorilla in the corner that I was sort of referring to the other day. We know that you may speculate about that issue, but you've already heard the judge tell you, you've already heard me say it, we'll both say it again. You're just not allowed to speculate about that issue. It can't be any part of your decisions in this case. 12/27/2009, approximately 10:15 in the morning. Elizabeth Johnson is at the Tornado bus station in Texas. You're going to hear evidence about that. You're going to hear evidence that Elizabeth Johnson was there alone. Gabriel was not with her at that point. You're going to hear that Elizabeth bought one bus ticket to Florida at the bus station so she could travel to Florida. Gabriel is not with her at that point. There's going to be no dispute on that point. About an hour and a half later, a little bit more than that, 11:53 a.m., same day, 12/27/2009. You've already heard about the text. We're not going to dispute that text. She sent it. It said, "I killed him." There's not going to be a dispute about that. That's the text that Elizabeth Johnson sent to Logan McQuarrie on December 27, 2009 at 11:53 a.m. Immediately following that, just like you heard from the state, there's going to be evidence about it. Defense is not going to dispute it. There was a telephone conversation recorded by Logan McQuarrie that allegedly gave details about what had happened to Gabriel McQuarrie. Those are the inflammatory type details that you just heard. You're going to hear that. We don't dispute it. There's a bus that left the Tornado bus station on that day, some period of time after noon, after that text message is sent, after those phone calls, those recorded calls are made, and Elizabeth Johnson starts her journey to Florida. We don't know exactly what happens at that point. But we do know on December 30th, 2009, that's the date that Elizabeth Johnson is found. She's found in Miami Beach, Florida. We don't dispute that either. She's arrested in Florida. No Gabriel. No evidence of any Gabriel. She's alone. She then talks to the police. Police ask her the obvious questions. Where's Gabriel? We're looking for Gabriel. We heard you killed Gabriel. Where's Gabriel? She responds, I didn't kill Gabriel. She tells the police a different version of events. She explains that she gave Gabriel to a couple in the San Antonio park back in Texas. She gives some limited details about that couple. Limited details about the park, where it is, what it looks like, what the streets are like on the way. That's not an issue in this case. You may hear other evidence in this case as we go through this trial. You're going to hear lots of other pieces of evidence. Things that go to things like, was Elizabeth Johnson a good mom? You've already heard some pieces of evidence about that. You may already have an opinion about whether or not Elizabeth Johnson was a good mom. You're going to hear other pieces of evidence as we go through this trial. Was Elizabeth Johnson a good girlfriend to Logan McQuarrie? Did she say mean things? Did she lie about Logan kidnapping Gabriel Johnson? I'm going to ask you over and over again to focus on the elements of the crimes that are charged. And I'm going to ask you to think about whether or not these issues, these things that I just discussed, have anything to do with those elements of those crimes. That's what I'm going to be talking to you about. This case isn't about whether or not you like Elizabeth Johnson. It doesn't matter to me whether you like Elizabeth Johnson or not. My job is to do my best to get you to focus on the elements of the crimes charged. Indeed, that is your job. I'm going to ask you simply to do your job in this case. Nothing more and nothing less. I'm going to ask you not to be distracted. There are lots of distractions in this case you haven't noticed. Lots of distractions. There's going to be lots of distractions as we go through this case. I'm going to ask you not to be distracted. There's going to be emotion in this case. I'm going to ask you to do something that might be difficult, to not make a decision based on your emotions. You already know from jury selection, this isn't about emotions. This isn't about speculations. That's going to be the difficult part of my job as we're going through the case. I'm going to ask you to do those things. Indeed, you have a duty not to do those things. The judge will give you the law at the end. The judge is going to tell you that it's only about the elements of the crimes charged. Now, there are going to be witnesses as we go through this case. In a criminal case, generally we have lots of witnesses. Some of them are there to do things, as we like to say as lawyers, to sort of complete the story. It's not fair to give you little bits and pieces of only just the relevant information. You have a right to hear the entire story of what happened, and we understand that. So you're going to hear witnesses along those lines. I'm going to tell you right now, so you'll know as we're going through the case, the defense isn't concerned about those witnesses. The defense isn't concerned about those issues. The defense is concerned only with facts and evidence that go to one thing, the elements of the crimes charged. So there may not be much cross-examination in this case. As much as I like to do cross-examination, there may not be much. There may be some witnesses with no cross-examination whatsoever at all. The state may finish some witnesses, And the judge may say, Mr. Victor, your turn for cross-examination, and I may say no questions. Other witnesses, I may have very few questions on. I am not going to take your time with issues that don't go to the elements of the crimes charged. I'm going to ask you to keep an open mind. The judge has already told you in the preliminary jury instructions that's part of what you're required to do here today. I'm going to ask you not to speculate about those things I know you want to speculate about. I'm going to ask you not to speculate about the current status or the whereabouts of Gabriel Johnson. And I'm going to ask you to remember, this is not a case about whether or not you like Elizabeth Johnson. And at the end, when I come back here in closing argument, which I promise you will be much, much longer than my opening statement, I can assure you of that, I'm going to ask you to do what I'm telling you I would like you to do right now. Focus on the elements of the crimes charged. I'm going to come back in closing argument, and I'm going to walk you through each element of each crime. And I'm going to review the evidence with you. And I'm going to say, did the state present evidence to convince you beyond a reasonable doubt of each element of each crime? That's what your job is. I'm not going to ask you to do anything more or anything less than that. Thank you very much for your time.
Thank you, Mr. Victor. Okay. Ladies and gentlemen, I had told you, I think when we were selecting the jury, that we were going to end early today, and I thought at that point it would be 2:30, but here's the good news. We finished before lunch, so we don't have to come back after lunch, and we're not starting the testimony, so you're going to get a super early release today, which is right now. We're going to come back Monday. Remember, we have Fridays off, obviously. We're going to come back Monday, and we're going to start at 10:30, and then we'll start testimony. Expect to have full days then, Monday through Thursday of next week. For testimony, and of course we have the calendar, and we have more copies of the calendar for you. One thing I didn't mention to you, I know you were provided with a calendar, a different calendar, in your notebooks, and the attorneys have agreed or stipulated that you be provided with that calendar in case you want to use it to take notes, because as you can hear, the attorneys may be talking about dates at certain times, and if you want to use that calendar, you can. Okay, so now you're going to have a long weekend where the trial's actually started. There may be media coverage of the trial, and now people may just flat out ask you, are you on the Elizabeth Johnson jury, or are you involved in that case? And now you're basically going to have to say, I can't talk about that. Remember, we discussed in jury selection, if people just flat out approach you and say, you're on that case, aren't you, and try and engage you, you need to disengage and tell them, I can't talk about it. I can't talk about any aspect of it. You can only talk about the trial schedule and the fact that you're a juror. It may be challenging as you go into the weekend. Sometimes you see people on the weekend you haven't seen all week and they want to know what you're doing. But you need to make sure you don't talk about the case, and need to make